Take it back. You keep laughing. You laugh one more time, that's 30 days. Go contempt.
A defendant gets pulled from the courtroom twice before this arraignment is even finished. A judge issues a 30-day contempt sentence in real time. And at the center of it all is a man who insists the person named in the charging documents simply isn't him. This is People of the State of Michigan versus Thomas Styron II, and it's one of those hearings where the legal stakes and the courtroom tension escalate at the exact same pace. Styron is facing 3 charges: fleeing and eluding police in the 3rd degree, assaulting, resisting, or obstructing an officer, and driving on a suspended license. 2 of those are felonies. 1 carries up to 5 years in prison. But before the judge can even get through reading the charges, things go sideways. Laughter in the courtroom leads to a contempt warning. Then a second interruption leads to an actual 30-day sentence, and Styron begins arguing that the legal entity named in the complaint is a different person than the man standing in the courtroom. It's a legal theory you may have seen described online as strawman or legal fiction arguments. And like most courtroom theories built on that foundation, it runs headfirst into a judge who has heard it before and isn't going to let it derail the proceeding. We're going to walk through exactly how this hearing unfolds: the charges, the contempt ruling, the discovery dispute with the public defender's office, and the moment Styron is warned, point blank, that more consequences are coming if he doesn't change course. Let's get into it.
Case People versus Thomas Styron. Here we go.
The public defender Ortella on behalf of Mr. Styron, who stands to my left. Well, let's talk to the judge about that, right?
For the people.
We've been through this. Seems to be some confusion.
What's the confusion?
I stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you're charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here. You understand, first of all, that if you do be direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take it back. You keep laughing.
Let's pause here, because this identity argument is worth unpacking. Styron is drawing a distinction between Thomas Styron as a person and Thomas Styron as what he calls a legal entity on the complaint, essentially arguing the court has jurisdiction over a legal fiction, not over him personally. This is a well-documented argument style, and courts across the country have addressed it the same way every time. Your legal name is simply the name used to identify you in official proceedings. It's not a separate person, and it doesn't create a loophole around the charges. What's notable here is how the judge handles it. Not by debating the theory, but by declining to engage with it at all, and instead repeatedly asking a much simpler, narrower question. Do you understand the charge? That's a deliberate move. Under the law, a judge doesn't need a defendant to agree with the charges, only to be informed of them. So even when Styron won't answer directly, the judge is building a record that the charges were read and explained, which matters a great deal if this case is ever appealed. Keep an eye on how quickly this escalates from there.
Laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. First calls the case of the People versus Styron. Recall. State your name.
My name is Thomas Styron. I live in man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the motor vehicle code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's two different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding third degree?
So,
Do you understand the nature of that charge? You just need to answer my question.
for the record,
Take him back, and when he decides he wants to cooperate, we'll bring him back, maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days! Recalls the case, people of the state of Michigan versus Thomas Styron II. Styron, you are before the court on a...
Let's put the numbers on the table, because this is where the case stops being a legal theory exercise and becomes very real. Between the felony fleeing and eluding charge and the felony resisting and obstructing charge, Styron is facing a combined maximum of 7 years in prison and thousands of dollars in fines before you even get to the misdemeanor. And he's doing all of this while representing himself, after already being removed from the courtroom once and hit with a 30-day contempt sentence for a second outburst. Here's the tension I want you sitting with. The judge, to his credit, still walks through every count, every potential penalty, and every right Styron has, including the right to a public defender, which Styron has already declined. That's not optional for the court. It's constitutionally required, regardless of how a defendant behaves. But it also means the record shows clearly that Styron was told exactly what he's facing and exactly what his options were. So the question is, when this case moves to a preliminary examination, is Styron's self-representation strategy going to hold up under real cross-examination? Or is today's contempt sentence a preview of a much rougher road ahead? Let us know what you think in the comments.
On a felony complaint that does allege count 1, and I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding third degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration or $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court cost. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. We're also entitled to be represented by counsel at this and all subsequent proceedings. If you could not afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee.
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Styron. I tried to speak with him and go over it, but I'd be happy to turn that over to him at the first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Styron so that he has the discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said,
Well, first of all, watch your
You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a SQB trust matter involved in this? Is my social security number attached to this at all? Go figure.
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continued.
So here's where this one lands. Thomas Styron appeared before the court on 3 charges, 2 felonies and a misdemeanor tied to fleeing police, resisting an officer, and driving on a suspended license, while choosing to represent himself. Along the way, the hearing was interrupted twice, resulting in a 30-day contempt sentence the judge confirmed would be served. The court walked through every charge, every potential penalty, and every right Styron had, including reaffirming his right to a public defender, which he continued to decline. The judge also ordered that outstanding discovery materials be turned over the same day and set a preliminary examination for June 11th. What makes this hearing worth studying isn't just the tension in the room, it's watching how a judge keeps a proceeding legally sound, even when a defendant is actively pushing back on the court's authority itself. Every warning, every recitation of rights, every pause to confirm understanding. That's a judge building an appeal-proof record in real time. If you found this case as gripping as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.